My name is Dr. Martha Rumore, and I'm the head of the Frier Levitt IP and FDA groups. I'm also a PharmD, JD, and I'm admitted to the United States Patent and Trademark Office Patent Bar. I focus on pharmacy and healthcare law, pharmaceutical and medical device intellectual property, and food, drug, and cosmetic law, including all facets of both 503A and 503B compounding, support for USP 797, 795, and GMP requirements. I represent pharmacy compounding clients on a range of regulatory issues from FDA inspections and state board matters to PBM audits. I have 20 years of law firm experience in these areas, and I've held director level roles in regulatory affairs with the pharmaceutical industry and hospital pharmacy. I'm a frequent lecturer. I have over 200 publications and presentations, and I'm a fellow and former trustee of the American Pharmacists Association. I'm pleased to be joined by my colleague, Arielle Miliambro, a senior partner at Frier Levitt, as we explore strategies for navigating the rapidly evolving GLP-1 landscape. We're going to discuss recent litigation trends, including claims around medical necessity and the corporate practice of medicine. We're going to review emerging GLP-1 formulations and examine the growing influence of insurers and PBMs in what was once a primary cash pay market. We're going to also cover key legal and regulatory considerations for clinicians prescribing these therapies. Arielle, could you please introduce yourself?
Sure. Good afternoon. My name is Arielle Miliambro, and I'm a partner in our regulatory department here at Frier Levitt. I focus on both life sciences and healthcare matters related to telehealth and digital technology, fraud, waste, and abuse, and professional board rules such as those relating to corporate practice of medicine and pharmacy practice. I frequently work on matters that involve marketing relationships, management service organization models, physician ordering and dispensing, and other arrangements that implicate various state licensing board rules.
Thank you, Arielle. Before we get started, just a quick few housekeeping items. The webinar is being recorded. You'll receive a link to access the on-demand replay in the next few days. Please note that while we are attorneys, today's discussion is for informational purposes only, and it should not be considered legal advice. We'll be addressing these topics at a general high level. If you're interested in more in-depth conversation, we'd be happy to connect, and our contact information will be provided at the end of the presentation. We're going to try to get to as many questions as possible. If you have questions during the presentation, please use the Q&A tab. Be sure that your name is visible so we can follow up if we're unable to address your questions live. If the questions come up afterwards, we encourage you to reach out to us at any time. So let's get started. First slide, please. So these are just our learning objectives. We've kind of just gone over, basically, I mentioned that in the intro, strategies for navigating the evolving GLP-1 landscape, because it's currently at a crossroads. We're going to gain insight into some recently filed lawsuits that are alleging things like lack of medical necessity and corporate practice of medicine. We're going to look at some newer GLP formats that address patient needs. We're going to explore the evolving role of insurers, PBMs, and other payers in this previously cash-only business. And we're going to look at some impacts of clinicians prescribing GLP-1s. Next slide, please. So GLP compounding right now is at a crossroads. At play are many moving pieces. We have the OFA lawsuits against the FDA over removal of tirzepatide and semaglutide from the drug shortage list. Those litigations, they're ongoing. The preliminary injunction rulings in both cases going in the favor of the manufacturers. Judge Pittman ruled that semaglutide and tirzepatide are in sufficient supply, and therefore essential copies cannot be compounded. And so while the manufacturers may have won round one, an appeal has been filed to the Fifth Circuit of Appeals, and given that the demand for GLPs we would expect that both sides to continue litigating these cases. 503A compounders can still compound, but not essentially a copy. That involves things like greater than plus or minus 10%, different routes, and other things that are described in the FDA guidance, but also pursuant to medical necessity. An example of medical necessity would be something like to prevent an adverse event, such as nausea and vomiting, by adding an additional ingredient, such as pyridoxine. Also at the crossroads that we could bring up at this point, the numerous manufacturer lawsuits. In fact, there were 111 lawsuits across 32 states just from Novo Nordisk. That in and of itself is placing GLP-1 compounding at crossroads, with some compounders scaling back or not compounding entirely. A few weeks ago, the tirzepatide manufacturer filed a new series of lawsuits aimed at telemedicine platforms, and there is a claim in those some of those cases that it's alleged that there is a lack of medical necessity, and specifically in the complaint, the manufacturer is alleging that a GLP-1 plus another drug, here in these particular cases, glycine or L-arginine, those combinations and those unique formulations are falsely being claimed to have medical necessity. In essence, in these cases, the manufacturer is actually attacking at the very basis of compounding, which is that the formulas are personalized. The manufacturer is claiming that these compounds are mass manufactured, they're not for any individualized purpose. And the crossroads also involve other things like availability. We are aware of at least some prescribers that have sent letters to patients that they're no longer willing to prescribe the compounded versions, and they're citing things like FDA, the case, the OFA case, and FDA warnings. The crossroads involve availability, they involve access of commercial product, and costs, which continue to be much less for the compounds. Next slide, please. So some trends that we're seeing as far as insurers, PBMs, and other players, and this slide basically is talking about the commercial product. And I think it's important that compounders are aware of the entire landscape out there. There is a GLP-1 coverage conundrum. Employers are facing challenges to add these GLP-1s into their group health plans, and they're trying to balance the costs against the interests of participants and beneficiaries. Only about 10 to 15% of the plans cover for weight loss at all. And a primary argument for coverage is that other healthcare costs related to obesity may decrease if these drugs are covered. However, in 2025, there was actually less coverage for GLP-1s despite increased demand. But the plans are increasingly reassessing their GLP coverage policies. They seem focused on utilization management strategies such as greater than a certain BMI. That would limit, off-label use where the patient's BMI is too low. They're looking at increased deductibles. They're looking at step therapy for weight loss, other agents used first. They're also focused on rebates, and things like that. The PBM reform could mean greater access to weight management medications, but right now there's no margin to be made in filling GLP prescriptions if all the pharmacies are reimbursed at equally low or below cost levels. And low GLP-1 reimbursement rates are a significant issue for pharmacies, especially small to medium-sized independent pharmacies. There was a NCPA survey recently of pharmacies that said that something like 90% or more are actually losing money because the costs of acquiring the GLP drugs often exceeds the reimbursement they receive from insurance companies. So a large percentage of the pharmacies are claiming that they're actually losing money. The profitability for the PBMs lies in the rebates. For every prescription that's filled, the PBM receives an agreed upon rebate from the manufacturer. And at this point, the PBM is able to decide how much of the rebate it's going to keep. Usually it's disguised as hidden fees like clawbacks, DIR fees, NDC upcharging, the list goes on. And whatever is left, if anything, it goes to the employer group. So the PBMs are trying to negotiate larger rebates for these drugs by leveraging their power over the formularies since they retain so much of it. In fact, CVS Caremark just announced a deal with Novo to give preferred formulary status to Wegovy. They're removing Lilly's Zepbound from their formularies by July 1st, 2025, to better manage their GLP-1 spend. And so that's a major shakeup in the market for the GLP-1s. It has the potential for migration away from compounding pharmacies to the 9,000 CVS stores, with 9,000 new opportunities for patients to receive the brand medications. Next slide, please. So are compounded GLPs a viable lower cost option? There are a lot of entrepreneur type ventures going on. We've had one thing I've noticed is a lot of venture capital companies, they're reaching out more and more. First, they just reached out and they wanted information about 503A and 503B compounding, but now they're actually presenting some deal opportunities and talking about different partnerships. About the telehealth explosion that's coupled with a rising popularity of the GLP-1 medication. A few weeks ago, Novo actually partnered with a major telehealth company to offer its branded weight loss product through the company's online pharmacy directly through telehealth platforms. And that's somewhat of a truce because Novo had previously sparred with the three telehealth companies it's now partnering with over selling the compounded version. Similarly, Eli Lilly has teamed up with a telehealth company to offer vials of its weight loss drug, Zepbound. So a couple of the things we're seeing, some plans may cover the compounds if they're medically necessary and there's no suitable commercially available alternative exists. There are still strict and complex rules. They could deny if specific ingredients are used. There is some reluctance on the part of prescribers that the supply won't hold and that they need to switch patients to the brand product. I mentioned the letters that we've actually seen. On the other hand, insurers are facing increasing pressure to cover these drugs. The obesity discrimination claims are very interesting. Most states, with a few exceptions like Mississippi and Louisiana, do not consider obesity to be a disability under the ADA unless it's caused by an underlying health condition. But Washington State includes obesity as a disability under its non-discrimination laws, and multiple lawsuits have been filed in that state alleging that the exclusion of GLP-1s from the health plans is discriminatory practice. There's also been lawsuits filed in Maine for the same thing under the Maine Human Rights Act. There is a possibility that obesity could be considered a disability under Section 1557 of the Affordable Care Act. But so far, there's been like one or two lawsuits and they haven't been successful. There is a Treat and Reduce Obesity Act, the TROA, which seeks to authorize Part D coverage for FDA-approved anti-obesity drugs, including the GLP-1s. The bill's been reintroduced in several Congresses, but unfortunately, the CMS proposal, the final rule doesn't include coverage for anti-obesity medication for Medicare for plan year 2026. Next slide, please. So this slide, very quickly, I'm ran out of time. I just wanted to go over, these are just some of the newer formats. We have the different formulations with B12, pyridoxine, glycine, NAD. These are the compounded ones. There are biosimilar generic versions in development. They could enter the market as early as 2027. The FDA has accepted Novo Nordisk's NDA for an oral formulation. And the decision is expected by December, and depending on the price point, this could erode the compounding of injectables, so it's something else to keep in mind. Of course, it may just go on the 506E FDA shortage list, which is a possibility. So the competition is growing. The GLP pipeline, it's robust. There's 124 drugs, that are under investigation, and there are 8 of them in phase 3. And there's some other newer agents, like the last one that's on the slide there. Next slide is just the same thing I went over already, is those recent lawsuits. And I think my colleague's going to go into the corporate practice of medicine a lot more. I would just mention in these lawsuits, they do have an uphill battle because they're looking at a medical necessity standard, which is basically the Medicare standard, versus what the FDA actually has in there, essentially a copy guideline, which is clinical difference standard. And it's a subjective clinical judgment, and there's deference traditionally to prescribers. And with that, I'll turn it over to Arielle.
Thanks, Martha. Thank you, Jamie. So I'm going to discuss the complaints recently filed by Eli Lilly against several telehealth companies. The lawsuits target Fella Health, Henry Meds, Mochi Health, and Willow, and all of the above are accused of unlawfully marketing and selling unapproved tirzepatide products. So today I'll walk you through the core allegations that are being made by Lilly, why these complaints are as much about structure and compliance as they are about marketing, and the legal framework for corporate practice of medicine, which underpins 2 of these cases. I'll also talk about what the lawsuits mean for prescribers, pharmacies, and telehealth platforms. And most importantly, what you can do to stay compliant and reduce risk exposure. At first glance, the 4 complaints are trademark and advertising lawsuits. So they're centered on false advertising and unfair competition. But with a deeper look, especially at the complaints against Fella Health and Mochi Health, it reveals broader concerns that are tied to state law issues. Lilly raises detailed allegations involving corporate practice of medicine violations, particularly in California. So it's not just about unauthorized drug marketing or competition even, it's attempting to expose a larger issue about who's controlling patient care decisions. And for both prescribers and pharmacies, that should raise red flags. Next slide, please. So the corporate practice of medicine, these laws exist in many states to prevent non-physicians like corporations or tech platforms from influencing clinical decision-making. The rules are meant to preserve the independence of providers so that medical care is guided by patient need, not corporate profit. In 2 of the recent complaints, Lilly alleges that the non-physician owners of telehealth companies, which are not, they're not clinical entities, they were either directing the activities of prescribers or they were directly providing medical advice in violation of corporate practice of medicine rules. Again, and so the complaint, particularly the Fella Health complaint, it embeds screenshots from Reddit that depict non-clinical executives allegedly communicating with patients and advising as to treatment. And so there's allegations that the entire patient population of the platform was also switched from an essential copy compound to one that contained an additive so that it would no longer be considered an essential copy, and that was done at the direction of the non-clinical executive team. Both of those allegations, if they're true, could be damning with respect to a corporate practice violation, depending on the state. But it's important to clarify that a manufacturer wouldn't be able to enforce a corporate practice of medicine violation. And there's really no mechanism for recovery for a manufacturer with respect to a corporate practice violation either. So instead, Lilly is purportedly using these allegations to bolster its unfair competition claim. But there may be greater strategy to it than that, which I'll get into momentarily. In terms of corporate practice generally, these laws can vary significantly by state, and they really fall on a spectrum. So by way of example, New Jersey is a strict corporate practice of medicine state. In New Jersey, a non-clinician can't own a medical practice or hire a physician to see patients. And this is a critical point. In our practice, we've seen many telehealth companies created by unlicensed individuals who then hire doctors and pay them to provide services. And often all of the parties are not even necessarily aware that they're violating corporate practice and medicine rules. The providers in these models in particular can face discipline, even if they're unaware of the underlying structure. When we start talking about telehealth models, things can get even trickier. So some folks think that when they're structuring their business, if they choose a state that doesn't have corporate practice of medicine rules, then they can just use that entity and render care to patients in any other state while only abiding by the flexible state's rules. But that's not generally the case. The law that controls is going to be the law where the patient is located. So let's say a Florida company hires a New Jersey licensed provider to treat patients in New Jersey via telehealth. The practice structure is going to have to comply with New Jersey corporate practice of medicine rules, not Florida's more relaxed rules. And because a physician that's licensed in New Jersey can't treat a New Jersey patient through a Florida formed entity, that's not going to work. California is a similar example where physicians need to practice through a California formed medical corporation, not an out-of-state entity. So for any providers that are listening in today, this should concern you. And we know that a lot of clinicians are generally providing telehealth services on a part-time basis through these platforms. It's usually a secondary or even tertiary income stream. But participating in an improperly structured telehealth model can put your license and livelihood at risk. And state medical boards absolutely have sanctioned providers in many different states for ceding their medical judgment to non-clinicians or following preset treatment protocols without independent evaluation. Corporate practice violations come with pretty serious consequences, including license suspension, like I mentioned, or revocation. It can invalidate contracts. There's civil liability, and there can potentially even be criminal charges to the extent that the corporate entity is deemed to be engaged, or individuals at that entity are engaged in the unlicensed practice of medicine. So just consider a hypothetical, but this is very realistic and pretty common, where a telehealth company hires a prescriber, non-clinicians at the company create treatment protocols for GLP-1 medications. They decide what dose a patient gets and how quickly they escalate doses or titrate doses. And then the prescriber follows that protocol. That's a textbook corporate practice of medicine violation in a number of states, and the prescriber can be held accountable for participating in that. In terms of what a compliant model would look like, separating clinical services from the administrative functions of the business is important, especially when it's owned by non-clinicians. From there, the administrative entity would then enter a contract with the practice to provide non-clinical support services. And that can include things like marketing and website hosting and development and branding, tech setup, administrative staffing, billing and collections. But the MSO can't control the clinical decisions. It can't employ the healthcare providers directly. It also can't 1099 them, and it can't influence how care is being delivered. Even if the MSO were to, say, hire a medical director or similar physician consultant, that person can't direct clinical protocols that will interfere with the independent medical judgment of the provider who's actually treating the patient. And they especially can't do this as a medical director on behalf of the MSO, or that can certainly lead to corporate practice issues. Next slide, please. So in terms of the impact of these lawsuits, even before they're resolved, we're already seeing a chilling effect on GLP-1 marketing. Companies are scrubbing their websites, they're pulling ads. Folks are making these business decisions as to whether to roll back some language or just remove content related to GLP-1s entirely. And some of these organizations believe that even if they just have the word tirzepatide on their website, that it's going to make them a target. And it very well may. But it doesn't necessarily mean that the content is inappropriate just because it's going to elicit attention from a manufacturer. That being said, websites are the first source of scrutiny for a manufacturer, and given Lilly's recent lawsuits and willingness to sort of lay it all on the table, so to speak, with what they find, companies with GLP-1 marketing content, whether that's social media ads or landing pages, should be looking to button that content up. We're also seeing providers stepping back from platforms that pose legal risks, and we're expecting this to continue. Like I said, a lot of clinicians, telehealth opportunities on larger platforms are second or third streams of income, so they're not likely to view the potential risk as worth the scrutiny when it may lead to discipline or suspension of their license. And strategically, that may have been an intended consequence of the content and the depth of the complaints plural that Lilly filed, because it aligns with their goal of having just fewer compounded prescriptions issued. We're also anticipating a demonstrable increase in regulatory scrutiny in this space. While this is something we've been predicting for a while, complaints like the ones that have been filed by Lilly essentially give regulators a bit of a blueprint for investigation and enforcement. Next slide, please. In terms of whether you're a clinician, a pharmacy, telehealth platform, what you need to be considering now is evaluating your business structure, ensuring compliance with corporate practice and other relevant state laws, reviewing management service agreements that may be in place, and making sure that there's not an overstep from that MSO to the practice in terms of clinical care. You want to be scrutinizing your marketing and your web content from an FDA perspective. You also want to consider FTC compliance, IP compliance. In terms of the specificity of how a lot of the GLP-1 models are operating, you need to also consider that sweeping changes to an entire patient population's prescriptions can be a negative factor when determining whether the prescription was issued really for a patient on a tailored basis, an individual basis for a particular clinical purpose, or whether it's just pretense to avoid the limitations associated with the end of the shortage. So that's something to absolutely consider, and was certainly a consideration in some of these complaints. Like I said, whether you're dispensing medications, prescribing them, managing the platform that's connecting patients and providers, Lilly and Novo are going to continue to pursue their strategy to shut down as much of the GLP-1 compounding as they can. And their waves are likely to lead to additional regulatory scrutiny as well. So don't wait to really evaluate your model with your counsel and adjust it as needed while you can. Next slide, please. So I actually think we're right out of time, but if there are any questions, Martha and I will get back to you by email. I want to thank everyone for joining us today. We hope you found the discussion insightful and informative. We've hosted several webinars on this topic, offering deeper dives into the evolving challenges that different stakeholders face, and a link to all of those presentations will be included in the follow-up email that you'll receive. If you have any questions or would like to discuss any of these issues further, please don't hesitate to contact either of us. We're here to support you as you navigate these issues. And thanks again for your participation. Hope everybody has a good day.